mother having been an OFW who left her under the care of an underachieving father who lived off his wife's remittance from abroad and squandered such remittance in gambling. So, in effect, Jane struggled all the way to graduate school, eventually finding a niche as a full professor at the Manila University in 2002. In other words, she was a go getter. So, Norbert entered marriage at 28 years old, still under his parents' wings without fully understanding the essential rights and obligations that marriage implied. And despite the telltale signs of some quite negative qualities in his future wife. By his own admission, he said, I was infatuated with her. So, sometime in 2005, we started talking about marriage without really considering the more important factors of emotional compatibility and a shared value system. I finally proposed during dinner in an expensive restaurant, giving her a ring. For her part, Jane accepted and agreed to marry me. So the wedding that followed was almost totally orchestrated by Norbert's doting mother, with nothing but the best intentions for the couple. Married life would be under the shadow of Norbert's paternal home, or better said, maternal care, with Norbert not having the means to live separately. In itself, it was innate, things came to a head one day when Norbert took the side of his mother against his wife in a conflict over the testimony of a domestic helper regarding a dent that the aforementioned car, because they had loaned the family of Jane a car, had suffered. In itself, it was inane, but it caused a wound that would fester for the next 3 years. The issue was always Norbert's perceived inability to provide the effective and financial support that Jane needed or demanded, and his inability to establish financial independence from his parents so as to set up a separate home for him and his wife. In September 2009, 3 months short of completing their third anniversary, Jane decided she could not take it anymore and simply left, never to look back. So that was the case. Now, the law. Canon 1095, paragraph 2 of the Code of Canon Law states that the following are incapable of contracting marriage. So that is 1, 2, 3. And then 2 is those who suffer from a grave lack of discretionary judgment concerning the essential matrimonial rights and obligations to be mutually given and accepted. In a celebrated sentence by Pinto, now Dean of the Roman Rota, we read, in order for a person contracting to be able to understand the nature and import of the conjugal contract, he or she must have the maturity of knowledge and freedom to establish the contract, and the degree of this is indirectly determined by taking into consideration the formal object of matrimonial consent. One who contracts must be capable of understanding, estimating, weighing, and freely determining himself or herself to establish a perpetual and exclusive conjugal partnership ordered towards the procreation and education of offspring by a will immune or free not only from external pressure but also from internal psychological coercion. That is, with full ability to choose. Let's say jurisprudence. In that same sentence, we read, as we already note, often an abnormal relationship between the party and his mother, that is to say, mammism, there's even a term for it, namely, an Oedipal relationship, causes not only an incapacity for eliciting valid consent, but also because it molds dependent personalities which are dominated by others, accompanies at the time of exchanging consent simulation of true intention of the one dominated. In other words, when you have such a complex, such a psychological anomaly, then the quality of the consent can be questioned, whether it was thought out properly, whether it was free, or there was an internal coercion because precisely of that Oedipal, in this particular case, or that complex of dependency. In this particular case, for example, it's obvious that Norbert was affected by the desire of his parents that he settle down. And they happened to like the woman, by the way, because she was nice, she was beautiful. And so, therefore, okay, this is the in law, the daughter in law that we want, at least at that time. Of course, after a while, when she began to assert herself, it became a source of conflict. But okay, that's moving, getting ahead of us. No? So, further down in that same sentence, we read, in the realm of Canon 1095, paragraph 2, as far as the proof is concerned, one must examine carefully the psychic life of the one who is presumed unfit, having maintained the distinction between one's curriculum of life and psychological condition at the time of manifesting consent. It is the responsibility of the expert to shed light on the existence, nature, origin, and gravity of the habitual or transitory anomaly, together with its effect on the critical and elective faculty to freely choose the state of life, while the evaluation of the conclusions of experts' report is the responsibility of the judge after carefully weighing other circumstances. So that's what's in the law. That's what the law states. That experts must be consulted to explain the nature of the psychological anomaly, its incidence on the thinking process, whether it's the thinking process that's affected, the thinking, the determination of that particular consent, or it's paragraph 3. It affects a person's capability to deliver, to, what do you call this? Not just to assume, but to exercise, fulfill rather, the obligations that he is consenting to. That's what has to be judged. And it's the judge, the tribunal, who will judge that. The expert, the psychological expert, can never say, or perhaps they will say, but the court should not take it into consideration that a person is therefore incapacitated or incapable. No, that's up to the tribunal to decide. Okay. Now let's go to the argument of that case. Again, I insist you should have read this case beforehand. The grave lack of discretion on the part of Norbert, the husband petitioner, as regards the essential obligations of marriage is proven by the following evidences. First is Norbert's own testimony in the signed case history, where his modeled reasoning for getting married was, 1, we dated steadily for 8 years, from 1999 to 2006, with lots of fights. She turned out to be a domineering and demanding person, getting mad at me when I could not meet her demands, like clothes, grocery items, and dermatological treatments. You see, they were still dating and she was already demanding such things. To avoid fighting, I would just give in and give her what she wanted. I had the financial means to do so. Nevertheless, I was infatuated with her. So sometime in 2005, we started talking about marriage. You see how muddled that reasoning was? Number 2, I just figured that since we had been dating for 8 years and my family liked her, we might as well go to the next step. So without really considering the more important factors of emotional compatibility and shared value system, I finally proposed during dinner in an expensive restaurant, giving her a ring. For her part, Jane accepted and agreed to marry me. In other words, what determined his decision to marry was not so much his own understanding of what marriage to Jane would entail, but rather the flimsy reason of their having dated for 8 years and his parents, especially his mother's, approval of her. Second, that was the first argument, is the psychological evaluation of Norbert by a well-known psychological center. After 2 assessments in March 2017, a report was made in April 2017 where we read, number 1, Norbert's test profile suggests the presence of dependent features in his basic personality structure. So dependency. He is more of the passive type of person, willing to yield his autonomy to others. Behaviorally, he is acquiescent and agreeable, willing to give in to others just to keep the peace. As it is, he places importance on relationships and is one to be devoted and loyal once committed. If you isolate that point, no, that he tends to be sweet, but behaviorally he's acquiescent and agreeable. So, in other words, um, handled properly by the woman, he can be a good husband, no? Handled properly. As it is, he places importance on relationships and is one to be devoted and loyal once committed. He can be a loyal husband, even. Number two, Norbert's dependent personality is also characterized by a long-standing need to be taken care of and a fear of being abandoned or separated from important individuals in his life. Specifically, in this particular case, his parents, specifically his mom. This leads him to engage in dependent and submissive behavior that are designed to elicit caregiving behaviors in others, and his dependent behavior may be seen as being clingy to others because he fears he cannot live his life without the help of others. He too has difficulty making everyday decisions without an excessive amount of advice and reassurance from others, and may resort to doing things that are unpleasant just so to maintain the support and approval of others. In other words, at the time of the celebration of the marriage, Norbert was suffering from an over-dependence on his parents, especially his mother, such that their expectation of his getting married in due time and their approval of Jane became the deciding factors for his marital consent rather than the deliberation of what marriage to Jane really implied in terms of the essential rights and obligations that it implied. Third is a psychological evaluation of the husband petitioner presented by another psychiatrist, presented in the course of the cause for civil case for the declaration of nullity of the marriage in question, in which we encounter some very interesting things. One, he projects strong ambivalent feelings towards his mother, suggestive of unresolved Oedipal situations. With his marriage, he hoped to undo emotional fixations, but he was hostile and angry because of unstable nature, as well as a yearning to be loved and cared for because he just couldn't break old family ties. This is further manifested in his inability or low sex satisfaction with his wife as a result of unconscious guilt feelings of defying his mother's love. At this point, he had difficulty in delineating between his mother and his wife. Number two, based on the above clinical findings, it is the opinion of the examiner that Norbert had manifested strong clinical signs and symptoms referable to a dependent and inadequate personality disorder along masculine strivings, secondary to an unresolved Oedipal situation, while Jane has presented strong clinical evidence of histrionic and immature personality disorders that render them both psychologically incapacitated to assume the duties and responsibilities of marriage. Note that this particular psychologist has already made conclusions that only the ecclesiastical tribunal should make. The root causes of the above clinical conditions on the part of Norbert was his close and prolonged attachment to his mother, beyond appropriate age, to a level of unresolved Oedipal situation, giving rise to his inadequacy along masculine strivings. In other words, as far as being masculine and the shall we say hmm, the yearnings of a man were concerned, his was undeveloped, or at least immature. In adult life, he had difficulty in delineating, putting demarcations, delineating between his mother and his wife. Because of too much pampering and babying, his emotional development was arrested along the infantile stage and didn't reach maturity, giving rise to his dependence on his mother. While the finding of an unresolved Oedipal complex is quite relevant To understanding the case, the conclusion by this psychiatrist of both the spouse's incapacity to assume the obligations of marriage illustrates a common equivocation in civil courts regarding this cause of nullity. In effect, the civil courts fail to distinguish between the cause of nullity typified in 1095 paragraph 2, grave lack of discretion of judgment regarding the essential rights and obligations of matrimony, and paragraph 3, incapacity to assume the obligations of matrimony for reasons of a psychic nature. It is here where the above-mentioned affirmation of the Roman Rota comes to mind. It is the responsibility of the expert to shed light on the existence, the nature, the origin, and the gravity of the habitual or transitory anomaly, together with its effect on the critical and elective faculty to freely choose the state of life, while the evaluation of the conclusions of expert reports is the responsibility of the judge after carefully weighing other circumstances. In this case, Norbert's dependent nature and unresolved Oedipal complex does not render him incapable of fulfilling the essential rights and obligations of marriage. Rather, they clouded his judgment regarding getting married to the particular person of Jane, who was headstrong and domineering. In other words, if not for the strong dependence on his parents' expectations and approval of Jane, he should have realized that she was not the kind of woman who could be his conjugal partner for life. The problem was not so much Norbert's, or for that matter, Jane's, supposed incapacity to assume the essential rights and obligations of marriage with a different partner. Norbert with a more supportive and understanding woman, and Jane with a more assertive and independent man, it would be reasonable to assume that both parties would have been capable of fulfilling their respective spousal rights and obligations. The tragedy in this case was that Norbert's psychological makeup led to his error of judgment in consenting to getting married to this particular person who precisely was the most counterindicated for his dependent character flaw. After having seriously weighed the principles in law and in fact, the undersigned therefore responds to the view as follows. Affirmatively, there is proof of nullity of the aforementioned marriage, since it was entered into by the husband while suffering from a grave lack of discretionary judgment concerning the essential matrimonial rights and obligations to be mutually given and accepted. I happen to be the ponente in this particular case. Okay? Now, I will entertain 15 minutes of questions in this particular case, but in order to do that, I have to start my video. Start video. There you are, video. And there.
Father, someone is asking where can they read the cases? Where can they read cases? Because you were suggesting that we read cases to develop that sense of what to help us out spot the issues.
Okay, you have to. Okay, I'll give you several sources, but normally these are ecclesiastical journals. One of them is the Journal of the Canon Law Society of the Philippines that gives you, by the way, these cases are normally, except for mine, because that's a local case, the tribunal cases are normally in Latin. Okay? So that's the biggest problem for you, because you don't need to read Latin. Sometimes they will be in Italian, which could be another problem, because you may not read Italian. Now, if you're lucky, or rather, law has nothing to do with it. Some journals translate those things to English, and those are published. One is the Philippine Canonical Forum of the Canon Law Society of the Philippines. And then another journal is so-called Monitor Ecclesiasticus. Another journal is the British Journal of Canon Law. And then another journal is the Journal of the Canon Law Society of America, CLSA. So those are canon law journals. What they will publish will be translations. Normally, the translations are, some of the cases I passed on to you, that's the way they are. But the English translations, normally what they do is, it's in English until it reaches the inura part. No? Then the inura is normally bilingual, the translation in English and the original Latin, so that the nuances are really there. Yeah, applicable to somebody who reads Latin, no? But for you, that thing won't be very useful. While the discussion, the argument, and the conclusion will all be in English already for the translation. Okay. Okay. Anybody has a question?
Um,
So
there are no more questions, Father.
there are no.
At least for now. Wait. Sorry. There's another question that just suddenly came up right now. Is the petitioner or respondent allowed to forum shop for psychiatrists?
To what? To?
Forum shop for psychiatrists.
Okay. No. He is appointed. I mean, the psychiatrist is appointed by the court, because of course the court has to be assured of the impartiality of the psychiatrist or the psychologist, because otherwise it can be doctored, so to speak, no?
And there's a question here: would the cause in this case merit for the civil nullity of marriage? But I think it was mentioned in the facts, Father, that it was in fact granted
Yeah.
the civil declaration of nullity.
Yeah, the civil declaration was obtained first before they went to ecclesiastical court.
There are no more questions, Father.
Okay, in that case, let's have a 5-minute break for people to do whatever. Can you see it? Can you see this? Mhm. Share screen. There you are.
Grave defect of discretion of judgment, exclusion of the good of the spouses.
Yes. Oh, there you are. Okay. Welcome back. We go to the second case that was decided in 2013 at the Roman Rota level in answer to a case that was filed in the US. So imagine if it reached the Roman Rota, it means rather, that it was granted nullity in the first instance, reversed in the second instance, both in the US, and that's the reason why it reached the Roman Rota for the final adjudication of the case. And what is the case? Well, Margarita Santana, a Catholic petitioner in the cause, was born on 19th of January 1960, and Jaime Gonzalez, respondent, also Catholic, born in the 18th of November 1952. Met in Rome at the beginning of 1983 when both were studying theology and had chosen rather religious life in two religious institutes. So this is they're both religious. The young people, attracted by sympathy, began a love relationship, and the engagement period proceeded without serious difficulties. Look at the dates. This is 1983. This is the height of the post-conciliar crisis, right? All the romanticism. Had this been 10 years earlier, then I could have faulted the what do you call the Sound of Music for it, but this is already 1983, more than the Sound of Music. I don't know what they were thinking. Therefore, almost 2 years later, they celebrated the marriage. Look at the choice of the date, 8 December 1984. That's the feast of the Immaculate Conception. So you can see that they are very religious people. The woman was 24 years of age, and the man was 32 years of age at the time. Look at the age difference. For several reasons, the married life did not proceed well, despite the birth of 11 children. Can you imagine? And a cohabitation which lasted 19 years. So they lived together for 19 years, had 11 children, and still they said it wasn't going well. However, during 2004, especially because of the behavior of the man towards his wife, the parties obtained the so-called divorce on 3 September 2004 from the competent tribunal, civil court in the US. Of course, 2004, both Catholics, married in Catholic Church, they get a divorce. On April 19, 2006, the woman petitioner presented a libellus before the tribunal competent by reason of the place of marriage, accusing the nullity of her marriage on the ground of defect of discretion of judgment on her own part. And on the 8th of November 2006, the doubt was formulated with a formula equivalent to her petition. In other words, the way she filed the, what do you call that thing? The bill of complaint that she filed, that was the cause. That was fixed, which was a grave defect of discretion of judgment concerning the essential matrimonial rights and duties mutually to be handed over and accepted on the part of the petitioner. Or, so they put two grounds: simulation of intention against the good of the spouses on the part of the respondent. Let's understand this well. In the bill of complaint, they cited two grounds. The first one was lack of due discretion on the part of the woman, so therefore 1095 paragraph 2. And also simulation on the part of the man. I can't remember anymore what canon that is. However, the tribunal, after carrying out the instruction of the cause, the investigation of the cause, during which the petitioner, the respondent, and witnesses introduced by both parties were examined in the typical American way through letters. You see the way the Roman Rota took exception to that, not because you're not supposed to do things that way. Depositions are supposed to be done in person. If people are supposed to appear in court, only exceptionally, because they're in a different country, will they be allowed not to appear in the court, in the tribunal where the case is being tried, but rather go to the tribunal, ecclesiastical tribunal, in the place where they reside. So they will still have to appear, never just through letters. Without seeking any expert report, pronounced an affirmative sentence on 14th of August 2007. So you see there the way the Roman Rota is already reacting to a failure of the process in the US. No? Number one, the depositions were done through letters. Number two, that they adjudicated the case, which the canons say should include the participation of psychiatrists, experts, medical experts. On the 23rd of August 2007, the man respondent properly interposed before the Rota an appeal together with the plaintiff of nullity against the first instance sentence. I don't know what was motivating him because the nullity had been granted. Then he must have complained such that in the appellate court, still in the US, it was reversed. And now in the Roman Rota, he's still complaining. So in other words, he's complaining against the declaration of nullity. Why? Think about it. Why should he be complaining if they're fighting and they already got a divorce? Look into the previous notes and you will see, you will intuit the reason. Because it must have been granted on the ground of simulation on his part of the simulation. He doesn't want to admit the fact that he was simulating, right? Anyway, so for him it was a matter of principle. He didn't want to appear like the bad guy in the case, even if both of them wanted the case to be the marriage rather to be declared null. So he was not going to get the declaration of nullity by hook or by crook. He won't be the crook, in other words. Sometimes that happens, you know. Okay, on August 2007, the man respondent interposed before Rota. By decree of the opponents, dated February 14, 2008, the plaintiff nullity of the first instance was dismissed at the outset because it lacked any foundation. But this sentence was not confirmed at this apostolic tribunal through the abbreviated process according to the norm of Canon 6 and 8 with paragraph 2. But the cause itself was remitted to an ordinary examination in the second grade. So they pushed it back to the second grade. The appellate court, in other words. The decree remitting the above cause to an ordinary legal process, Boca Folla, is one of the what do you call this? The Rotal judges. Then the opponents appropriately noted. First of all, it says, it seems that the sentence cannot be confirmed because the tribunal, by neglecting to seek an expert report from an expert in psychological or psychiatric matter, violated the provisions of law of both Canon 1574 and Canon 1680. In this cause, an expert report is absolutely necessary. Therefore, during the supplementary instruction in this grade of trial, what grade of trial? The Supreme Court, the third grade, an expert report was prepared on the acts of the cause by the ex officio expert, Professor Francesco Luciano. In order to protect the rights of the petitioner, an ex officio advocate was appointed in this process. But the respondent party, asked by the tribunal to choose or designate an ex officio advocate, remember the respondent is the man, failed to respond for a very long time. Therefore, in order to avoid further useless delays, it was decided to proceed to the discussion and definition of the cause. Opponents defined by the decree of June 2009 the doubt discussed under the following formula. So finally, the joinder of the issues, the so-called joinder of the issues, fixing the object of litigation, put this as the doubt. Whether there is proof of nullity of marriage in the case due to defect of discretion of judgment in the woman petitioner according to the norm of Canon 1095, paragraph 2, and or due to the exclusion of the good of the spouses, bonum conjugum, on the part of the man respondent according to the norm of Canon 1101, paragraph 2. So lack of discretion on the part of the woman, simulation on the part of the man. Therefore, after the acts of the supplementary instruction were published and the written defense.
All right. Sorry.
What's happening there? Therefore, after the acts of the supplementary instruction were published and the written defense briefs prepared both for the woman petitioner and for the validity of the bond of marriage. People have to mute. After the turnus was reconstituted by the decree of the Dean dated 13 February 2013, the cause is now ready for decision in the second grade of jurisdiction. Okay, sidebar here. Let me explain a few things. I think we cannot avoid this. I was trying to avoid it. The outline of the process is as follows. For the lawyers, they know this very well. For the non-lawyers, this could be an introduction to the process. The process, which as we said before, the judicial process is a series of steps. That's why it's called a process. Procedural acts designed to arrive at moral certainty beyond reasonable doubt regarding the truth of the case so that the court can declare it. Okay? How does it happen? The court, or rather the process, is introduced by an action of one party. Remember what we said about the action is the right of a subject of the law to go to a competent tribunal demanding redress for a right that he thinks has been violated or for a right that he thinks is not clearly stated. So that's a petition to introduce the cause. The second step would be that the court will cite the respondent to answer that particular charge. What does he have to say, whether he agrees with it, or what does he have to say, for example. And he's given a 2 weeks to answer that. If he fails, he's given another 2 weeks. If he fails, he's given another 2 weeks. That's what causes delays when people don't respond. And then finally, when he responds or he doesn't respond, then the court will have to fix the doubt, the object of litigation, the cause for investigation. Fix it based on what the petitioner or the actor has said, and what the respondent has said. That's why it's called the joinder of the issues. They join the two things and come up with, okay, this is what we're going to investigate. If the respondent hasn't responded, then of course the court has no other recourse but to just take the complaint or the petition at its face value, everything on the side of the petitioner, and then make that the ground to be investigated. What has been alleged by one party alone, because the other party has chosen not to respond. So it's not true that a petition dies just because the other party does not respond. It will move forward. But the only thing is it may move forward one way or another way. In this particular case, since the party didn't say anything, then it went forward according to what the petitioner said. Okay. So that's what you call the joinder of the issues. From that moment of the joinder of the issues, then the whole procedural or processal scenario is fixed. You have a judge, you have an actor, and you have a respondent. And they are litigating a particular matter. So that's complete. Before that, it was not yet complete. Notice that before that, at the very beginning, it was just the actor saying something, establishing a link with the tribunal, who acknowledges that link by saying, okay, we'll investigate this. And then the tribunal will try to establish a link with the other party. So depending on whether that party answers or not, then that link is established. If it doesn't answer, then there's no link. It's just these two. But if there's a link, then that's the joinder of the issues. They will establish what the real issue is, and that closes the triangle. That's the procedural or processal relationship or situation. That's a juridic structure there. Okay. Then next is that the so-called instruction of the case. This is judicial or juridic terminology. When you say instruction of the case, it means, it comes from the Latin word instruere. To instruere is to inform oneself of. So the instruction of the case actually refers to the gathering of proofs, witnesses, etc., etc. That's where all the depositions will come, because in the matrimonial court, or rather in matrimonial procedures, the process.
Hello? I'm back. Can you hear me? Yes, Father. Yes, Father. Yes, Father.
Cases, in such cases, well, I got distracted there. What was I saying? Yeah, the depositions are done one by one, and for as long as it takes. And then when everything is gathered, that's the instruction of the case, then it says that the court will declare that the case has been sufficiently instructed and will close it. Now, you hear that sometimes, that the case has been closed. When it says closed, it doesn't mean that it's over. It just means that the instruction phase has ended. No? That's the conclusion of the case. And then it goes to the next part, which is the judgment of the case. That means the judges, the tribunal will study it. There's opponents. One of the three will write out the paper, will write out the sentence, and it will be passed to the rest of the tribunals. And that's the sentencing. So from the judgment, then it becomes sentencing, the final phase, when the sentence is decreed and communicated to the parties. And that will be then the last part of the case, which is the promulgation of the case. The parties are called together and the sentence is read to them. So that's the scenario. And within 15 days, they're given the chance to complain. If there are no complaints, or if the defender of the bond doesn't complain, then it becomes executory. Before, the defender of the bond had the duty to automatically elevate it to the appellate court. But Pope Francis has removed that. So if there's no complaint, there's no move in 14 days or in 2 weeks, then it becomes executory. Okay. After that sidebar, let's continue with this. So the joinder of the issues has taken place, and it's going to be tried on 2 grounds. One, the lack of due discretion on the part of the woman, the petitioner, or the what do you call this, a simulation on the part of the respondent, the man, for having excluded the good of the spouses in his consent. Now, let's look at what the law says. It is evident from the jurisprudence of our Apostolic Tribunal, this is the Rota writing, remember, so our Apostolic Tribunal was referring to themselves, that discretion of judgment to judge does not concern speculative judgments, but rather practical judgment about the marriage to be contracted here and now. This practical. Again, for those of you who are not used to such terminology, look, there are two kinds of judgment: speculative, theoretical, or practical, regarding practical things. Not just considering, speculating, but a matter of the here and now, an actual situation. That's what you call a practical judgment. But then, a practical judgment can still be theoretical in a way, because it's not moving into action, or it does not lead to action. Or really practical, which means it demands action. And this is what this is, practical. When you get married, you're definitely not speculating on what the nature of marriage is. Something practical, you're speculating, you're thinking now about marriage to this particular person now. So that's a practical judgment. Not just practical, but practical, because it's now. You're going to give your consent now. You're going to get married now to this person. In the concrete, but not in the abstract, namely concerning this marriage to be contracted by this man with this woman, in the concrete circumstances in which the same marriage should be celebrated, taking into consideration the future fulfillments of the duties. So that's practical. Not every defect of discretion of judgment, however, renders matrimonial consent invalid, but only that which is really grave, as ecclesiastical law expressly provides in the 95, paragraph 2. Therefore, Blessed John Paul II had warned that for the canonists, the principle must remain clear that only incapacity and not difficulty in giving consent and in realizing a true community of life and love invalidates a marriage. Now, I was very happy with the way some of you stated this with so much conviction in your answers to quiz number 12. Or was it 14? Quiz 14, rather. Regarding, no, not quiz 14. Basta. Regarding 10.5.3, no? That the so-called incapacity to assume is not really, sometimes I don't like the way that thing is formulated, incapacity to assume. Anybody can assume. But invalidity of assuming because of the fulfill what you are assuming. And all of you have understood that. That what's at stake here is the incapacity to fulfill the commitments that one is assuming. So therefore, it generates, by law, it's the law that generates it, the incapacity to assume. Because by nature alone, it's not an incapacity to assume. I can assume. But the law says if you cannot fulfill it, then by law, you're incapacitated of making that, you're incapacitated from assuming those commitments. You see? So it's a legally generated incapacity. Because by nature, I insist, one is not incapacitated from giving that consent. As a matter of fact, that's the origin of the whole problem, because here's a person who committed themselves to such obligations in front of witnesses, in front of the church, in front of the altar. So he did it. He was capable of doing it. But the law says, no, you shouldn't be capable of doing that because you're incapable of fulfilling what you're committing yourself to. It's a nuance, but it's important to get these nuances in law. And besides, it's what makes the whole thing interesting. Okay? Jurisprudence also requires that this defect of discretion be both grave and antecedent to marriage. That is at least present and efficacious at the time of celebrating the marriage. Because the formal causes of grave defect of discretion of judgment can be manifold, and in the canonical forensic realm, the concepts of mental infirmity or psychic anomaly are used in a very broad sense. Assistance of experts must be used in these causes. Unless it is clear from the circumstances, the confection of expert report would be useless. So unless that's very clear that that's useless to do that, then it should be. Let's go to what exclusion of the good of the spouses the bonum conjugum means. So the expression bonum conjugum was assumed into the new code, which states as follows: the matrimonial covenant by which a man and a woman establish between themselves a partnership of the whole of life, and which is ordered by its nature to the good of the spouses and the procreation and education of offspring, has been raised by Christ the Lord to the dignity of a sacrament between the baptized. So that's a statement of law, a juridically structured, constituted statement that that's what the end of marriage is, the good of the spouses. First of all, there arises the difficult question concerning the definition of the expression good of the spouses. That really is a problem. One reads the following about the matter. According to our opinion, sometimes the question must be turned around in such a way that the good of the spouses, the bonum conjugum, is understood and rendered efficacious through right and relative obligation to communion of life. Note what it's saying. The jurisprudence is saying that the good of the spouses, what it means is communion of life. Because think about it. Just think about it. No? When you talk of the perfection of the parties, not perfection of the parties as human beings, but perfection of the parties as parties in a marriage, then what it's really leading to, or what it's implying, is the good of the parties as conjugal parties, as man and wife, in other words. So therefore, somebody who enters marriage disregarding that aspect, what aspect again? Their good as husband and wife, their fulfillment as husband and wife, their happiness as husband and wife, not just their fulfillment because they'll get more educated, or not even their fulfillment because they'll have children, period, or whatever other perfection there may be, but no, their perfection as husband and wife. If somebody were to get married disregarding that, then that's a clear case of exclusion of the good of the spouses. Note, disregarding doesn't only mean not thinking about it, but meaning to say excluding it with a positive act of the will. Sometimes it's just for sheer irresponsibility that the person gets married without thinking of that, in which case you ask, well, what were you thinking about, right? But that would not be a case of exclusion, which would be what do you call this thing? Simulation. But precisely it would be a case of lack of due discretion. He didn't think of it, but he should have. So therefore, the discretion was not there or was insufficient. You get the point here. This is very important because these are different levels of involvement of the intellect. One is pure disregard, when it should have been regarded. Another one is even an act of exclusion, that simulation. The first one is just an act of lack of due discretion. The second one is exclusion. Or it could be that one really wanted it. You know, I want the good of my spouse. I commit myself to the good of that spouse. But then 1095, or rather because of psychological reasons, it's shown that, but he cannot actually do it because he's narcissistic, because he has borderline personality disorder, or is strong bipolarism and things like that. In which case, the law says even if you committed yourself to that in your right frame, we ourselves, the law itself declares you're incapable of doing that because you're incapable of fulfilling that commitment. You see there the different grades, okay? In his allocution of 26 January of 2013 to the auditors of the Roman Rotang, the Supreme Pontiff Benedict XVI himself sheds light on this matter when he says that the bonum conjugum also assumes importance in the context of the simulation of consent. Of course, it will be the investigation in facto that will ascertain the possible grounds for this reason for annulment, prevalent or coexistent with another reason of the three Augustinian goods or bona of marriage, which is procreativity, exclusiveness, and permanence. One must not therefore disregard the consideration that can arise in the cases in which, precisely because of the absence of faith, the good of the spouses is jeopardized, that is, excluded from the consent itself. Therefore, we must conclude that the woman is another person for the man, and the man is another person for the woman. And complementarity can be understood in this way, which concerns not only the generative fact, but also the psychological difference of sex. This unity of the two allows formation of communion of persons and marriage. In order to circumscribe such a communion, the canon uses the expression mutually give and accept each other. This formula designates the material object of giving and accepting, which cannot be conceived except in relation to certain determined actions. And here I'd like to put the sidebar, because this becomes problematic in the case of same-sex marriage, or even people with gender issues. No? Because precisely what's being given here and accepted in a mutual fashion is the giving of one's personality appropriately sexed in the conjugability of male and female, of masculinity and femininity. So therefore, a person suffering from gender disorder or gender confusion will not be able to make this determination. And even if he did, it can be argued under 1095 paragraph 3 that he would be incapable of fulfilling what he's committing himself into or committing himself to do, which is to give himself as a man in a masculine way in that conjugal relationship, and to accept the woman as a woman who in a feminine way is also giving herself that he now is accepting. So there are gender problems that thing goes awry, no? Awry. So the ordination of marriage to the good of the spouses, the bonum conjugum, because it is an essential element of marriage, constitutes the essential object of consent. There are indeed the rights, obligations to a peculiar or specific behavior on the part of the spouses, which consist in the right to an intimate joining of persons and actions, by which the spouses mutually perfect each other, both with respect to the right to interpersonal relationship, specifically conjugal, and with respect to the right to behavior of the partner, through which the spouse will be able to attain his or her unique psychosexual complement of a true spouse. There are cases, we will study it in the next case, where you have precisely a homosexual man getting canonically married to a woman. There's a problem there, because this will get into the picture, meaning to say the interpersonal relationship, both in the physical and in the spiritual level, of a man and a woman in their masculinity and femininity. That no matter how you cut it, we can come up with all kinds of theories, but at the end of the day, they won't be able to do what a man and a woman are supposed to do when they are related by conjugal love. They can come up with things, The movies are replete of such examples and of such anomalies, but that's not the way it was made. It was designed by the Creator. So therefore, one who by a positive act of the will intends not to recognize the fundamental rights of the other excludes the good of the spouses. No one can doubt that the positive act of the will required by Canon 1101 to invalidate marriage can be either explicit or even implicit. But implicit will does not signify a generic or interpretative will of the contractant, but rather an intention that is at least virtual of excluding marriage itself or one of the properties or an essential element thereof, rooted in the habitual behavior of the one excluding or in the combination of circumstances of life of the same person. So, to the proof of exclusion of the good of the spouses, the following principles must be noted. So, these proofs, even if you're not going to go into this because the advocates and the canon lawyers, protagonists of the case, are the ones going to go there. But the relevance of this with you is even at the stage of the prejudicial marriage counseling, even in the stage of preparing the case study or the case history and the bill of complaints, you must keep in mind that these are the things that will need to be proven. So these are the things, therefore, that should already appear in the case history. These are the things which will need witnesses for corroboration, if at all possible. Otherwise, if you don't think of these cases, you can come up with a case history that's a nice history, but it's not going to go anywhere in court. It may, under just reading it reads like a novel. It shows that the marriage is invalid, but it cannot stand muster in a court of law. And the ecclesiastical tribunals are courts of law. No? So first, both parties are to be heard, who should report accurately to the judge why she, the woman, accused the marriage of nullity on the ground of exclusion of the good of the spouses by the man. 2, the witnesses shall be questioned, and these are to inform the judge about those things which they learned directly from the person simulating or came to know from others about his simulation. The witnesses shall report also the circumstances determined from the time, place, and persons. That's what I meant earlier when I was telling a witness, but that's hearsay because he doesn't know it firsthand, he only heard it. No? Third, the judge shall carefully inquire about the cause, either for contracting or simulating, and about all circumstances antecedent, concomitant, and subsequent to the marriage. Number 4, in case the elements of proof collected during the trials are considered insufficient to form moral certainty about the exclusion of the good of the spouses, then the decision must be for the validity of marriage, which enjoys the favor of law. In other words, remember that in these trials, what needs to be proven is the invalidity. The validity doesn't need to be proven. That's already taken for granted because the juridic act took place. That's a principle in law, no? That the juridic acts have the favor of law for their validity. And common sense will tell you that it took place. It wouldn't have been allowed to take place without due diligence. It took place according to the format which it should take place, with all the juridic guarantees, with witnesses. So therefore, in principle, that's valid. Now, if you want to prove that it's invalid, the burden of proof will be in you. You have to demonstrate it before a court. And this is what happens here. Okay? Now let's go to the argument of the case. After having examined and weighed all the acts of the cause, it seems to the undersigned auditors that the petitioning party has in fact failed to present any solid and convincing argument in favor of nullity of marriage in the case. You see, this is one case where the court is going to deny the petition because they did not prove enough. No? We already cited the fact that they even failed to bring an expert to speak of a psychological anomaly. Second, but the testimonial proof does not confirm so strong and grave conclusions the first instance judges had drawn, because it does not show the existence of symptoms of some serious disorder or anomaly on the part of the woman petitioner at the time the marriage was granted. Because think about it. They were relying on the fact that the woman was 24 years old. Okay, young, but not that young, 24 years, especially for a woman. At 18, a woman is perfectly lucid, and this is even a graduate student taking up theology in Rome. So, okay, to adduce, or to allege rather, a lack of due discretion at that age, at that level of education, the lack of due discretion will only have to be, what do you think? Because of fear? Because of error at that age? You still don't know what marriage is? Or precisely because of psychological factors? Perhaps not enough to render a person incapable of fulfilling the obligations that he's committing himself to, but yes, putting a cloud on how much thinking, how much due deliberation was given to generate that act of consent at the moment of giving it. So therefore, that needs the testimony of expert witnesses. And in this particular case, they failed to do that. They just repeated the fact that lack of due discretion, I wasn't thinking enough. Well, okay, you can say that until you're blue, but unless it's corroborated, then nothing will happen to it. In summary, the majority of the witnesses who were examined in the case had no doubt about the psychic capacity and about the right intention of the woman in contracting marriage. Of course, she was a nun, 24 years old. She knew what she was doing. Above all, the experts excludes and notes precisely that, and this is what the experts say, and this is what they exclude, a careful analysis of the elements found in the acts do not allow to qualify a diagnosable affective immaturity in the petitioner at the moment of the wedding as grave and such as to impede her from making an evaluation sufficiently free and responsible in respect to the duties related to the matrimonial decision. If you're attentive, you would have noted a careful analysis of the elements found in the acts. Why does it have to be elements found in the acts? It shows you, again, the experts, there were no experts that examined the witnesses themselves. Experts were called in afterwards to look at the after depositions. And of course, that won't fly, A judgment regarding the psychological state of a person based on the depositions before the court, not through an actual interview and evaluation of the subject. Well, that's a joke, right? Now, the arguments gathered from the procedural files are in fact inadequate for admitting with certainty that the petitioning party had lacked critical faculty in contracting marriage or sufficient internal freedom in choosing marriage with the respondent. Now, this is on the part of the petitioner, of the actor, lack of due discretion. But remember that there was a second, another cause, which was the exclusion of the bonum conjugum on the part of the respondent, on the part of the man. And again, there are no grave elements in the acts which can prove exclusion of the good of the spouses. By the way, note that exclusion is something internal, right? How can you prove that? Only two ways. One, confession by the party himself, admitting that, he excluded it. Which, by the way, can be foolproof. Remember what we said? An intrajudicial confession, meaning to say self-inflicted and incriminatory confession, is considered in ecclesiastical court foolproof. But there was nothing like that. The respondent didn't say anything like that. As a matter of fact, he's denying it. Because in the acts there is no express confession of the respondent, whether judicial or extrajudicial, concerning his intention to contract marriage without the obligation to procure his own good and that of his spouse in the communion of life, that is, in the partnership of the whole life. Because really, come to think of it, why should anybody exclude that? Especially if you're coming from this background and they were studying theology, right? A lot of words and facts that had occurred during the occasion of his relationship with the woman contribute much to our understanding of the man respondent's will. He says, eager to get on with life and being 31, I needed and wanted someone to love and serve and someone to love me in return. If I did not have much to offer, it didn't matter because I would devote myself wholly to my wife and God-willing children, and she would do the same towards me. This was my view of Christian marriage, the ordinary path to salvation. So they were thinking very well about what marriage was. But there is no judicial declaration in the Acts because Jaime wanted to enter into a true marriage with Margarita. In fact, he was faithful during marriage and tried to be a good father and husband. Jaime says, I accept responsibility for the vow I made to Margarita before God, to love, honor, and obey, for better or worse, for richer or poorer, in sickness and in health, until death do us part. The respondent chose a religious way of life known as Oblates of the Virgin Mary. He had experienced a very peaceful childhood in a middle-class family because his father was a medical doctor and had acquired an excellent religious formation. When he decided to pursue a true religious life, he was rejected by the congregation of religious because of his irascible character and lack of disposition to obedience. The man proved himself responsible when he speaks of marriage. I was ready for marriage and I thought she was a sweet girl. I thought she was a good person. As to difficulties in marriage, the man attributed them to the woman petitioner and explains even how deep-seated my wife's anger and emotional problems were. I worked extremely hard for her and spent myself into bankruptcy for her. From the declaration of the woman emerges that during the prenuptial period, he is very intelligent, had noble high ideals in some areas, and is very articulate. And thus, without himself affected by neurosis towards the woman petitioner, even desperately unhappy. The expert clearly concludes, sorry, there are no elements to believe that prior to and at the time of the wedding, the respondent had manifested a definite disorder of personality. Sorry, I have to call a timeout.
Water, Father, water.
Yeah, I will. But I will break 5 minutes. So from the declaration of the woman emerges that during the pre-nuptial period, he is very intelligent, has noble high ideals in some areas, and is very articulate. And thus, without doubt, there is no evidence that both before and after the marriage, the respondent had shown himself affected by neurosis towards the woman petitioner, or even desperately unhappy. The expert clearly concludes there are no elements to believe that prior to and at the time of the wedding, the respondent had manifested definite disorder of personality. So in these circumstances, the testimonial argument cannot support the petitioner's thesis. Nobody was able to report any extrajudicial confession of the man. Really, no instance has been brought forward, perhaps to further explain the ground of simulation of consent on the man's part. On the other hand, the witness, Reverend Gonzalez, respondent's uncle, says, at the time of the wedding, there's no doubt in my mind that Jaime was well aware of the responsibilities of married life. He knew it was meant to be permanent and could produce offspring, and he did not even consider the idea of getting a divorce. The witness, Carolina, confirms, I can testify to the best of my ability to each party's attitude during their married life. Each party knew that marriage was binding until the death of one party. The respondent taught me that all divorce has no weight as to the validity of marriage. He thought that all divorce is evil. This is Jaime. However, none of the witnesses dares to declare that the respondent had denied to his wife the right to observe fidelity. The statements of the witnesses, which certainly prove neither the alleged exclusion of the good of the spouses nor the opinions of the man concerning marriage, speak only of his character. The cause for contracting marriage is clearly proven in the Acts. According to the declaration or mind of the parties, the marriage was celebrated because of true love of the spouses. So after stating all that, then, four circumstances confirmed by the parties and witnesses during the trial are brought to light here. First, conjugal life lasted 19 years. Second, 11 children were born of the same marriage. Third, the separation of the spouses took place not because of some unusual behavior of the woman petitioner, but because of the alleged violent behavior of the respondent. D, we must note that the man wanted to save the marriage. He was opposed both to separation and to divorce. Therefore, there are no arguments for declaring with moral certainty the nullity of this marriage on the ground of exclusion of the good of the spouses, bonum conjugum, that is to constitute matrimonial partnership. So after having carefully weighed everything said in law and in fact, we, the undersigned fathers, auditors of the turnus, that means to say the tribunal, sitting for the tribunal and having only God before our eyes, having invoked the name of Christ, definitively sentenced, responding to the proposed doubt negatively. That is, there is no proof of nullity of marriage in the case of any of the alleged grounds. We thus pronounce, mandating the local ordinaries and administrators of tribunals to whom it pertains, that they notify this, our definitive sentence, to all who have interest in it with respect to all its legal effects. Given in Rome at the seat of the tribunal of the Roman Rota on the 21st of March, 2013. And then you have to look how big the Rota was for that particular case. No? 1, 2, 3, 7. 7, because the Roman Rota, unlike the tribunal at the diocesan level that has 3, the Roman Rota has 7. So the turnus, the tribunal, is 7. That's why tribune or tribunal doesn't come from tri. Because in this case, it's 7. Okay, any questions for this case? I think it's pretty clear.
There are several questions, Father, about the procedure and other matters, other related matters.
Okay.
Somebody's asking, does it mean that as advocates later on, we might have the chance to go to Rome if a case is appealed there too?
No, because well, yeah, but there are advocates in Rome that will be normally appointed by them because they do things in a very Roman way. No? Those are professionals. That's the reason why it's expensive to reach that level. At the Roman Rota, there are advocates, and you have to pay them.
Some questions about your comments on gender uncertainty.
Yes.
Does that apply also to ordination such that a person with gender issues cannot be a priest?
Yes.
Amul case.
Because the person asking the question says she has 2 male friends with gender issues who are considering the priesthood.
Well, especially with this pope, yeah, he has made it very clear after all the, because you see, most of the cases of sexual misbehavior of priests, sexual abuse of minors, most of them, really most, the preponderant majority were gender issues, are gender issues. They're cases of homosexuality, in other words. You know? Very seldom they have a case of sexual abuse of minors who, of the opposite sex. You know? So, because this has been a very bad issue for the church, precisely because of the confusion of the 1970s. All part of the, even though it was not called LGBT at that time, what it was called at that time was, what do you call this, liberalism, of giving equal opportunities to everyone. Why discriminate against people with gender issues, etc., etc.? So they admitted them in seminaries, they admitted them to ordination, and look, they're reaping the fruits. Because one requirement for priesthood is that it's not in the present canon, but in the old code, it stated it very clearly. It must be vir compos, meaning to say an entire man. No, you cannot have a man that has a problem with his masculinity. It's putting him. It's adding another burden to an otherwise an already burdensome, quote unquote, situation. To live celibacy for the kingdom of heaven is already a kind of a burden. It's a sweet burden, and for somebody who's in love and who has the proper dispositions and the proper psychology, it's affirming. But for somebody with problems, okay, that's complicating it. So that's a hindrance to even to admission to seminaries. It's one of the guidelines now. A problem, I mean, a person with gender issues should not be admitted to the seminary. Okay, next. What happened? What's happening? Chrissy?
Father, can you have slides when you left?
I'm sorry. What's happening?
Sorry, Father. I think Chrissy got disconnected. I'll just continue the question, the reading out of the question.
Okay.
Hold on. Was this read out already, Father? Does the failure to get expert testimony always ensure that... Sorry.
Not yet. That hasn't been tackled.
On that list, does the failure to get expert testimony always ensure that the petition will fail? For example, for lack of financial means to pay for the psychiatrist's fees, or obstinacy of a party to not subject himself to a psychiatric evaluation for fear of being branded as one of having psychological disorder.
Mm-hmm. Well, it's not a sure thing, but it sure is going to make it difficult because then you remember, you have to prove something, and a psychological evaluation is the only proof for the something where you are alleging a psychological anomaly. Now there could be another ground. That's what I stated earlier regarding Prince Charming, the narcissistic Prince Charming in Europe. The straightforward cause should have been his psychological incapacity. But since we couldn't prove that because of his refusal to cooperate, we had to attack another front. Luckily, there was another front which will be followed. So it's like that. No? You just have to be resourceful enough. Now, as to the expenses incurred in getting psychological evaluation, well, if really you can demonstrate to the court that you don't have the resources for that, well, there's such a thing as pro bono. The court may find a way to get a psychologist to evaluate the person pro bono.
Okay. I think Chrissy is back, but we're here at the question of Miss Dina Lucinario. Can you explain further about emotional or affective immaturity? For example, someone who cannot control his emotions as an indication of psychological incapacity. Some persons who suffer a breakup from relationships become emotionally devastated that they are not anymore able to function in life or even try to commit suicide. Is it an indication of emotional immaturity?
Well, I would say so. But then, you see, that's a typical case where a psychological expert will present expert testimony of just what constitutes that particular psychological immaturity and what are the the manifestations thereof, when it will have to be the judge to decide that a person with such an anomaly, with those characteristics, with those manifestations, will be unable to fulfill the essential obligations of marriage. He will have to make that connection. The psychologist cannot make that definitively, can suggest it definitely, but the judge has to make that connection in his mind to reach the certainty that this person therefore is incapable of assuming those essential obligations. That's why the 1095 is the most exciting ground. No? And reading cases of 1095 is one of the most quote-unquote fulfilling. It's tragic, of course, because all of those are tragedies, remember, but intellectually stimulating. Then you see the distinctions. And there you appreciate to what Rothel or ecclesiastical jurisprudence, how, is stratospheric it has gone compared to the positivism of the civil courts with regard to this matter. It's really, the civil courts is absolutely impoverished when it comes to this. Okay, nothing to gloat about, but it's something to rue about, that they have to get into this more seriously. And here's the point for those lawyers out there who are interested. And that's the reason why canon law, more specifically matrimonial law of the church, is a field of expertise for civil lawyers that still has to be explored in the Philippines and in the countries of Anglo-Saxon heritage. But in the Latin churches, or rather to say countries of a Latin root, like Spanish America, for example, the Hispanics, Argentina specifically, and definitely Spain and Italy, canon law is a real field of expertise. As I told you, I think I told you in the past that when I was doing my doctorate in the University of Navarre, I had two classmates from Argentina, lawyers, lady lawyers, who were getting a graduate degree in canon law because they want to specialize in matrimonial law, civil matrimonial law. In order to get deeper to it, to understand that even our family code and to get more out of it, if not to advocate for its improvement, is one of the things I really want to get into. Get fresh legislation to fine-tune the family code to make it more articulate, more logical, more systematic, and more consistent. It's going to make it look more like canon law. But hey, it's not our fault, that canon law happens to deal with matrimonial law very well. So it would just be coincidence that it's going to look like canon law. because that's the right way of looking at matrimony. Next question. It's already 4:10. What happened? You're gone again.
Next question, Father, is: was there ever a declaration of nullity for a long-term marriage, especially when they had many children? If ever there, on what ground was the declaration made?
Well, all kinds, 20 years. I know of a case that I adjudicated myself. They were 20 years, although they had been separated for the last 9. But it was a 20-year-old marriage that we declared null from the very beginning. That was amazing because they had children, several children as a matter of fact, and they were very nice kids. They were already in their 30s, but late 20s and 30s, but very well brought up, a lot of love for their parents. But you can really see there that they did a good job at raising them, but they didn't do a good job of being man and wife, because really it had nothing to stand on from the very beginning. It was circumstances that put them together, and they just tried to make the most of it, being responsible because they were children, but in the end it didn't work. So 20 years. I got another declaration. I did another declaration of nullity, more than 20 years, because the guy was as old as me. As a matter of fact, he was a classmate of my younger brother in medicine. So, almost as old as me. That means to say, they got married at, I don't know, at 30, 35 even. I'm 67, so that's 30 years before they got a declaration of nullity. So 30 years.
Yeah.
Psychological incapacity in that particular case.
Next question. Is collusion between parties accepted in churches' nullity cases? Because in civil cases of annulment or declaration of nullity of marriage, the court ensures that there is no collusion between the parties. Is this the same with that of the church tribunal?
Well, as I told you, it can happen that the two are co-petitioners in a what you call this thing, in a briefer process, right? So there's collusion there from the very beginning, because the objective of the ecclesiastical tribunal is to arrive at the truth. The position is that the spouses are coming before the court, asking the court to declare the truth. So therefore, if they want to maliciously collude away from the truth, they can. But that's a piece of paper that they're going to get. In the eyes of God, they're still married. Or the previous one was still married. So the ecclesiastical tribunal is not afraid of collusion. So the measures for safeguarding against collusion, very slight in ecclesiastical tribunal because of that assumption.
There's another question. Can it be said that one of the downsides of seeking a nullity under church laws is the emotional draining experience it entails, which may also lead to violent reactions? This is why some spouses just choose to silently leave the marriage. Is this a Christian reaction?
It's not, for the simple reason that, as we studied before, if there's a real marriage, the only correct position or situation is to be together. And one cannot just leave unless there's an imminent danger against life and soul. of a body and soul of a spouse, no spouse may leave the conjugal abode, right? And even when he does so or she does so because of imminent danger, then in the span of 6 months, he should get or she should get a writ from ecclesiastical authority authorizing such separation because they should be together. So it's not Christian to do that.
Are non-priests allowed to enroll and earn a JCL or JCD degree?
Of course. You know, in the European system, canon law is not for churchmen. It's a I told you already that my degree, my doctorate in canon law, is not an ecclesiastical doctorate. It's a civil degree granted by the state of Spain. It's like me going to UP. It's exactly like me going to UP, and I got a doctor of canon law. That's my status in the academia. It's not an ecclesiastical degree.
Can a parent or relative file nullity observing the problems and knowing the defects of the marriage?
No, we took that up before, no? That the only actors, remember when we studied who are the protagonists in a cause for nullity? So the only protagonists are the spouses, or in a special case, for filing, or when the public's good is at stake, the promoter of justice. Nobody else can file.
Or the same person was asking about JCLs and JCDs. He's asking, are the degrees granted by UST also civil degrees?
No, they're ecclesiastical degrees.
Okay. Then there's a question here about exclusion of the good of the spouses. What are the other means to prove it, in addition to confession?
I'm sorry, can you repeat that, please?
What are the other means on how to prove exclusion other than confession?
Witnesses, because a person may have talked about it and behaved. His behavior, imagine a person who's consistently using condoms. So he's excluding, right? Or by his behavior, you can see how he, shall we say, sows his wild oats carelessly. So he's excluding real
monogamy. Yes. I think there are no more questions, Father.
So because we have to move on to the next case.
Okay.
Just get the next case. Oops. So this is a case of fraud. You see this, no? Case of fraud? Hello?
No.
Hello. No, we're not seeing it, Father.
You're not seeing it. You're not seeing it.
Okay.
Mm-hmm. Oh, because it's a new share. No share. There, no share. Yeah.
Wait lang, Father. Sorry. Before we start, there's another question that I accidentally skipped.
Okay.
It's a question on whether there was a mention of in one of the cases whether there was divorce mentioned earlier in one of the cases that we discussed.
Yeah, the case in the States, they got divorced, civil law. That's
Okay,
it.
so I guess you can move on.
They got divorced, and then now they're filing in ecclesiastical tribunal to get a declaration of nullity. In the same way that the first case we had, they got the declaration of they got civil annulment before they went to ecclesiastical tribunal to try to get a declaration of nullity. Okay. So here is a case of fraud. The petitioner Jane was born December 1972 in Makati and presently resides in Quezon City. According to her disposition, her parents got legally separated when she was 6, whereupon her maternal grandparents got very much involved with her and her only sibling. Or only siblings upbringing by her mother. The separation of her parents left her physically broken. She was a sickly child and filled with insecurities. Okay. The respondent, Fernand, was born May 1973, so slightly younger than the girl, in Manila and presently resides in Quezon City as well. He was the eldest of 3 siblings, and according to the aforementioned deposition, his deposition was raised by a very strict mother who encouraged him to always be at the top of his class, which in fact he was, consistently from elementary school to college. His upbringing was characterized by a very strong maternal influence, a relatively laid-back father. By his own admission to the petitioner, when he was young, he was also sexually abused by one of his uncles, his mother's brother, something that he kept a secret to everyone except to the petitioner. In his deposition, the respondent admitted this incident. From the petitioner's account, the respondent's family was quite dysfunctional. His younger brother was a self-confessed homosexual, having confided that he too was abused by the same uncle as a child, perceived as such by his parents and relatives, as homosexual, having had no known relationships with the opposite sex and with feminine ways and attributes. And the youngest sibling, a sister, got pregnant out of wedlock at 16 years of age. So that's the background of Jane and Fernand. They met in 2002 while working at BDO as direct card sales channel managers. Spent our time together, thus instantly became good friends. Fernand started courting Jane in 2004, and despite persistent rumors in the workplace of his homosexual orientation, given his obvious effeminate ways, Jane slowly fell in love with him because of his very consistent, sincere, caring ways. Which reminds me of a joke of of a girl complaining. No? Where can I find a man who is sincere, caring, thoughtful, and doesn't have a boyfriend yet? Okay, so they became a couple in 2006, and in the next 4 years had a number of sexual encounters, getting consummated on 3 or 4 occasions only, despite having many, only consummated 3 or 4 times, since on other occasions Fernand could not. Because of persistent office rumor regarding Fernand's gender orientation, Jane asked him if he was homosexual or if he had relationships with men. He vehemently denied. So I took his word for it, which he was very thankful for. In his own deposition, Fernand admitted denying his homosexual orientation when he was asked by the petitioner. Fernand proposed marriage in 2008, and the couple started planning not only for the wedding, but for the future family that they would raise. They were both mature individuals and practicing Catholics, so their plans went along the general lines of the Catholic Church's teaching regarding marriage and family. The couple got married in December 2010, and as Jane recounts, on their wedding night, my husband just slept when we got back to our hotel room, saying that he was very tired. After a few days, they went to Boracay for their honeymoon, and nothing happened there either, as far as their marriage was concerned. Now, however, by 2016, remember they got married 2010, Fernand started to spend his weekends less at home and more in the gym or spending some Saturday night sleeping in his marathon buddy Arnold's place in Parañaque for an early Sunday run. For those of you who join runs and marathons or triathlons, you know very well that this normally happens on Sunday early in the morning. The gun start for a marathon is normally 4 o'clock. So you need to sleep very early and to be close to where the event is. So this is what was happening here. So after a couple of hours, or rather, in 2016, this started happening. It was in one of those nights in June 2017 that Jane received an SMS from a stranger, Emily, which said, do you want to know your husband's spicy secrets? After a couple of hours, Jane decided to respond to the mysterious SMS. What spicy secrets? To which the stranger replied, he eats dick at times, he's not there at night, and he likes being penetrated. So look at this very clinically. That very moment, according to Jane's narrative, I called my husband. It was already 26 June 2017 at 1 a.m. and told him to immediately come home. Came home at 4 and I confronted him with the SMS. I asked him if he was gay, and it was the first time that he admitted to me that he was. He broke down, cried profusely, attempting to jump off our veranda. He admitted to me that he had sexual relations with men when we met in 2002. He also admitted that during our marriage, he started engaging in multiple sexual relations with men since 2013, and that he stopped his multiple male relationships with men in 2016 because he met his marathon best friend named Arnold, who changed him to be faithful to one partner, Arnold. I told him I was very hurt, couldn't trust him anymore, and that I need to leave our home. So Jane left their conjugal home that same day in June 2016 and has been staying with her mother and younger sister in their ancestral home ever since. So the bill of complaint was filed at the Tribunal of First Instance, signed by both Jane as petitioner and Ferdinand as co-petitioner, and after due consideration was accepted by the judicial vicar for the briefer process according to the norms of Canon 683, etc. The criteria of the procedural norms of Mitis Iudex were met. Remember those two criteria. Number one, the agreement of both spouses to file for nullity. So they both signed off on it. There was no objection. And two, the concurrence of the special circumstances of a brief conjugal life and non-consummation of the marriage. And the doubt was formulated with the bishop as presiding judge in April 2018 as follows: whether the marriage celebrated between Jane and Ferdinand is null and void ab initio on the grounds, number one, inability to assume the essential obligations of marriage on the part of the co-petitioner, the man, or to fraud on the part of that same co-petitioner as provided for in Canon 1098. An instructor, defender of the bond, and assessor was appointed, etc., etc., and they had a meeting for the position on the 2nd of June 2018. Okay? Now, about the law, what does it say? 1098 states that a person contracts invalidly who enters marriage deceived by fraud, perpetrated to obtain consent concerning some quality of the other party, which of its very nature can seriously disturb the partnership of conjugal life. So what are the elements of the juridical structure of fraud? Number one, is perpetrated by one party for the purpose of obtaining consent from the other party. And number two, it's regarding equality of the guilty party, which of itself is seriously disruptive of conjugal life. That's the juridic structure. Number one, fraud, meaning to say withholding something from the other party for the purpose of getting consent. And two, that thing, the object of the fraud, is a quality which of itself is disruptive of conjugal life. Okay? Now, here you have, this is, I included this here because it's a wonderful discussion of what makes fraud invalidating. And the essence of the argument sa Pedro Juan Villadric, that should be a double L, Villadric. He's a Catalan, he's from Catalonia, he's from Barcelona, I think, who is one of the authorities of matrimonial law, canon law. He's not a priest, he's a layman. He's a father of several children. He's a very elegant layman. He was my teacher in matrimonial law, and fantastic. Huh? I can imagine him in court because he's theatrical. No? I mean, he acts out. He can, like those things that you see in movies of how these defense lawyers or these lawyers, trial lawyers, do things in court to convince a jury. Well, this fellow is like that, no? But anyway, since the spouse is the object of marital consent in itself, the falsification of the qualities by which someone is chosen as spouse amounts to another person's intervention to manipulate the object of the choice. In other words, in order to give a free consent, a valid consent, there must be the author of the consent must be the person who's consenting. That he must own it, the authorship of that consent. Now, when there is fraud, there's an interruption or an intervention or an intrusion into that authorship, because that element of fraud adds to the cause of the consent. So he's not the only cause of the consent. It's also that fraudulent information that was given. I bet you never heard an argument like that before. That you normally think of fraud. What makes fraud? Because it's the wrong information, period. No, this is a very elegant approach to it. That it's an intrusion to the authorship of the act of consenting. Okay, since the spouse is okay, let's go on. From the foregoing, it is clear that three elements are constitutive of fraud as an invalidating factor for marital consent. So this is the juridic structure of fraud. First is the fraudulent intention of the pars decipiens, the deceiving party. The active subject of fraud in Canon 1098 can be the other spouse or a third party. The role of pars decipiens, the deceiving party, is not limited to the other contracting party, and any third party can be the author of the fraud. That's interesting. The fraud can come also from another party, not just the other spouse, because the crucial effect caused by this error is the falsification of the object of consent, the effect on the one who's giving the consent, regardless of where it's coming from. It can come from the other spouse, but it can come somewhere else. The important thing is that it's causing that wrong or that unfree or that shared authorship of that act of consenting. So the canon requires that the fraudulent action is carried out with the pars decipiens with the aim of obtaining consent. This requirement is part of the general notion of fraud, which consists of any stratagem, deception, mendacity, or machination derived to provoke error. Therefore, the deliberate intent to achieve the end of the fraudulent action is the real core of the act of the pars decipiens. Second, the object of the deception is a quality of the other party, which of its very nature can seriously disturb the partnership of conjugal life. The quality that is the object of deceit must refer to the spouse other than the one being deceived, of course. It cannot be disconnected with the choice of a spouse, but must be intrinsic to the selection of a person as spouse. The quality can be physical, for example, sterility, or moral in the wide sense of the word, for example, psychic, juridical, social, professional, financial, religious condition of the party. For the effect to be invalidating, however, the legislator has restricted this wide spectrum of qualities to those that, by their very nature, can seriously disrupt the partnership of conjugal life. For example, if the quality that was hidden was, think of it, I mean, say he's a collector of manure, no? There's some, I know somebody who was collecting manure. Now, is that really disruptive of conjugal life? I didn't know that you collected manure. For as long as he doesn't collect them fresh and keep them in the bedroom, then that's not disruptive of conjugal life in itself, right? But however, if the part that was what do you call this withheld was the fact that he's a user, a drug abuser, or that he has some psychological anomaly that of itself is, for example, that he's what do you call this, a sexual pervert or whatever, or a profession which is unusual. I cited before that he's a double agent, or he's a spy, or he's a member of CIA or something like that. No, I don't want to be married to a spy. I don't want to be married to things like those. Okay. This conjugal partnership has su apte natura, two dimensions. Su apte natura, meaning to say by itself capable of two dimensions. The first dimension consists of the life partnership that is objectively and institutionally matrimonial. The one, an indissoluble bond aimed at the good of the spouses and to the procreation and education of offspring. The second dimension is the subjective life partnership of the spouses. That is the manner by which the subjective ends, in particular harmony with the objective and institutional ends, form a very personal conjugal life. The spouses choose each other under the influence of those qualities which they seem important in order to attain that twofold dimension of the partnership of conjugal life. The partnership of conjugal life, therefore, can be seriously disrupted su apte natura, by that very fact, by those two types of qualities. Now, when the quality on which the person errs because of fraud refers directly to the demands of the institutional essence, properties, or ends of marriage, and the relationship of the qualities to the serious disturbance of the partnership of conjugal life is proven ipso facto. Otherwise, you still have to prove it. What's the connection between that quality that was withheld with conjugal life? But if it impinges immediately on the essential qualities of marriage or the ends of marriage, like homosexuality, for example, or I don't know what, no, the inability to what do you call this? Inability to sustain one's spouse, inability to be with one's spouse for whatever reason. Imagine if you got married to somebody who's an astronaut and who has an upcoming mission to go to Mars, and it will be gone for the next 6 years. So what's that? I didn't know that. I didn't bargain for that kind of thing. Third, the cause-effect relationship between the fraudulent error and the matrimonial consent. So there must really be a cause-effect relationship, meaning to say that he gave his consent because of that error. It's not just an accidental thing. The reason for the invalidating effect of the ground of nullity foreseen by Canon 1098, fraud, is the causal link between the fraudulent act of the pars decipiens and the defective free consent of the pars decepiens, the deceived party. In other words, the deceived party would not have given marital consent had he or she known of that quality of the fraudulent party which had been fraudulently kept from him or her. A celebrated Roman decision, Coram de Filippi, that's another local judge of 1997, provided an excellent, and look at this, look at the way that's written, Coram de Filippi. That's the way the Rotal decision, Coram means before, no? Before the tribunal of which the presiding judge was de Filippi, of 4 December 1997. And then it will enclose in parentheses, Medellin, Colombia. What's that? That the case came from Medellin, Colombia, elevated to the Roman Rota, which means that in Medellin, which is the capital of Colombia, That was where the appellate court was. So it means, therefore, that that particular case had gotten nullity or not in a lower court, had been elevated to the appellate court in Medellin, and the two sentences had not concurred, so now it's been elevated to the Supreme Court of the Roman Rota in Rome. So that's the way to understand that. So this celebrated case, Coram de Filippi of 4 December 1997, provided an excellent synthesis of the juridic principles presupposed in Canon 1098 and their application to concrete cases. He outlined 5 practical points related to proofs in cases of deceit, which we shall follow in this case. First, define the quality of the other party about which the deceived party claims to have been led into error. Second, determine both the objective value of that quality, which has per se the potential for gravely disturbing the partnership of conjugal life, and the subjective importance which the deceived party attributes to that quality. Now, because sometimes a quality may really not be of itself disruptive, but for the deceived part, it is, because of the way she is. She's very finicky. She really has something to, I don't know what, and she has expressed it many, many times that, I cannot stand, pardon the slur, but it's just an example. I cannot stand, people from Mindanao. Just can't accept them. And then here's a guy who comes from Mindanao, from Davao, and hides it and gets married. And so it may be disruptive. In itself, coming from Davao is not disruptive of conjugal life, but for this particular person, she has a very strong objection to people coming from Davao, because maybe she had a traumatic experience in Davao, whatever. So, there. Third, establish whether the person who claims to have been deceived was unaware of the presence or absence of the quality before marriage, whether the deceived party was in fact in error. Meaning to say, led to error fraudulently. 4. Determine whether the error induced by alleged deceiver was indeed meant to extract the consent of the other party. Now, many times this is the difficulty, because really there's this quality, it's really disruptive, but then you also have to prove that it was perpetrated in order to obtain consent. How do you know that? Either an interjudicial confession or affirmations with witnesses that he or she was going to do this, deceive the other party. So it's not very easy to prove it. However, Rotal decision also shows that when the object of the deceit is directly related to the essential qualities of marriage, essential properties, then it's understood that if somebody deceives somebody for it, it's for the purpose of getting consent. I mean, try to make that connection in your head. That quality directly affects the essential qualities of marriage. So therefore, if you fraudulently withheld it, what was in your mind must be that, because it's directly connected to that. But otherwise, any other quality, unless the person states, or there are witnesses that he stated, or expressed himself, that he was doing it in order to obtain consent, then that's not presumed. It has to be proven. 5. Investigate whether the behavior of the party who contends to have been deceived after he or she had discovered the truth was consistent with the allegation that she defends before the ecclesiastical tribunal. That is to say, that the quality was indeed gravely disruptive of conjugal life. To say, if after having learned of it, nothing happened, it didn't really affect her. And it was only years later that he or she would accuse, would allege it, or would point to it, and that's not quite true. No? You can't say that it affected you because it didn't. In fact, if, however, the party alleged to be in error, that is, to have been deceived, terminates the common life or displays clear indications of mental grief, of frustration, even of indignation towards the one whom he or she considers to be the deceiver, presents several arguments in favor of nullity. This is the case in which we see that very evening that she discovered it, she left. She left the following day, as a matter of fact. The argument. Now let's see this particular case. The quality that is being alleged as the object of the deceit in this particular case is the homosexuality of the respondent. In his deposition, the respondent admitted his awareness of this gender disorientation since he was in high school, which became clearer when he stepped into the university. To his credit, however, the respondent had tried to struggle against that tendency despite not getting any psychological or spiritual help in that respect. Because this was the case. He knew it, but he had always been struggling against it, but nobody was helping him because he belonged to an era where one doesn't talk about those things for fear of being ostracized. B. Again, by his own admission, the homosexual tendency in the respondent can be traced to his childhood, where 3 out of the 4 usual factors leading to this gender dysfunction were present. To wit, the lack of a strong masculine father figure, given the laid-back character of his father. 2, a dominant feminine mother figure, with his mother wielding the baton in their family, and even prodding him to academic excellence all throughout his schooling. And finally, 3rd, sexual abuse by an uncle when he was a child. There are 4 factors that bring about gender confusion. These are 3 of them. The 4th is peer pressure. But the lack of the right gender parent, the absence of the right gender parent, the overpresence of the wrong gender parent, the mother in this case. 3rd would have been peer pressure, but there was nothing like that there. And 4th, this is the sexual abuse as a child. Those are the reasons why people develop this kind of gender attitudes. It's nothing to do with genetics. Nobody is born with a gender confusion. One is born only as male or female and learns the gender that corresponds to it by imitation in his very tender years. And precisely when the example is not there, or the wrong example is overly present, or there's peer pressure, or there's sexual abuse, does it shake the moorings of a child's moral development so that he's not sure anymore what gender he should adopt. And may adopt a gender which is contrary or other than his biological sex, his sex. Okay. Objectively, the respondent's homosexual orientation, and indeed his homosexual activity, is by its nature disruptive of conjugal life. Such a quality strikes at the very core of the institution of marriage in itself, which is a conjugal bond precisely between a man and a woman, as man and as woman, in the totality of their masculinity and femininity. Subjectively, on the other hand, the value that the petitioner attached to this quality is clearly proven. Given her Catholic upbringing from grade school to college and her own disappointment in the breakup of her own parents, the petitioner had very high expectations for an ideal marriage. Asked point blank, the petitioner categorically stated, "I would not have married Fernand had I known that he was or he is homosexual. I would not have even engaged in a boyfriend-girlfriend relationship with him." His position was corroborated by several witnesses, colleagues, etc. And then finally, the petitioner was clearly led into error by the respondent as regards his homosexuality by denying it specifically. Remember, she confronted him because of the office gossip and she said no. More than one of her friends warned the petitioner of such perceived effeminacy of the respondent, but due to the latter's outright denial of being gay, the petitioner clearly took his word for it, even to the point of not talking to her best friend for a year after taking offense at the latter's suggestion that the respondent might be gay. So up to the fateful night of their marital breakup, despite repeated queries by the wife petitioner regarding their absence of sexual intimacy in all their years of marriage, the husband respondent repeatedly withheld this fact of his homosexual orientation, preferring to explain away such absence of sexual intimacy with his wife to his tiredness from work and his decision not to have children anymore due to their age. Finally, the respondent himself admitted that because she confronted me with the question of his being gay, I denied her. Such fraud was perpetrated by the respondent in order to obtain marital consent. Aside from this obvious conclusion from the other facts of the case, there is no other conceivable reason why the respondent would not only withhold such fact from the petitioner, but even categorically deny it when confronted by the latter about his gender orientation. And that was, the respondent himself admits so much in his deposition to obtain consent, etc. So let's move forward. On the other hand, it's not difficult to surmise another ulterior reason for such pretension of the respondent to secure matrimonial consent and in fact proceed with the marriage, which was to improve his standing in his professional career. He was in the banking industry, and in the banking industry, gender or sexual, shall we say, integrity is valued. No? Somehow, a person with gender confusion is perceived as less reliable than somebody with the proper orientation in this regard. And so, poor guy, with all good intentions, rather, of just excelling in his work, thought that by getting married, he would improve his standing in the community. By the way, note that they had sexual encounters before marriage, 3 or 4 of which were consummated while the rest were not. But from the time they were married, from the honeymoon night, there was no sexual intimacy whatsoever for 7 years until they finally separated and the wife filed for declaration of nullity. Conclusion. After considering all the foregoing elements, in law and in fact, and after considering the animadversiones of the defender of the bond, in response to the dubium proposed, we, the undersigned fathers, auditors of the turnus, sitting for the tribunal of the diocese and having owned God before our eyes, having invoked the name of God, decide and declare affirmatively that there is proof of nullity of marriage in the case on the ground of fraud, as provided for by Canon 1098, perpetrated to obtain matrimonial consent on the part of the husband respondent, who therefore is prohibited from contracting a new marriage unless he proves before the local ordinary or his delegate that he has overcome his homosexual orientation, or that such quality is known by his projected spouse and agrees to it, given in the seat of the dead. Now, let me ask a question before you ask it. You mean to say that had the spouse known about the homosexuality and not have minded it and gotten married, that would have made the marriage valid? Answer, yes. Why? Because the invalidity of the marriage can be contested or impugned on 2 grounds. Number 1, fraud, and there was no fraud because the wife knew. Remember, consent makes marriage. And 2, because you can also argue with that. You mean to say that so what's the difference between 2 gays marrying each other? Meaning to say, same-sex marriage, they both agree. The difference is that here, it's not sex, it's gender. They are 2 different sexes. It's the gender orientation that's getting in the way. And it gets in the way if it gets in the way meaning to say the other party doesn't accept it. But if it is acceptable, it can be argued. It's kind of twisting, but it can be argued that they might find a way of making it work. But the thing is, if it reaches court, then that means to say it's not working. Therefore, that argument that despite the gender confusion, they're making it work won't hold. What am I saying? So therefore, can a man and a woman, and one of them is homosexual, is that marriage valid? It won't be under fraud that it will be invalid. It will be under what? 1095 paragraph 3. The incapacity to assume the essential obligations of marriage. In this particular case, the inability to fulfill the essential obligations of marriage, one of which is the end, remember, conjugal relationship, intimacy, procreation, etc., etc. Now, with that, we finish this case. I'm open for questions.
There's a question on Father, in the area of ethics, is there a process of requiring the prejudicial counselor to disclose potential conflicts of interest? For example, if one of the spouses or both was a client of the counselor in the latter's capacity as a family lawyer. As I foresee a scenario wherein the lawyer has information of relevance to the case, which he obtained as their family lawyer prior to the nullity process, but which the spouses would not sign up or agree to disclose at the current canonical process for whatever reason.
Well, you see, the problem there is that client, what do you call this, lawyer-client problem is in civil law, not in canon law. So that kind of evidence is perfectly admissible to the ecclesiastical court. But, okay, they may get into problems with civil law. That if the lawyer does that, he may open himself to civil suits, even criminal ones. Correct me if I'm wrong, you're the civil lawyer. That's a violation of a lawyer-client relationship.
Yes. Confidentiality, I could think of one ground I could think of is a violation of confidentiality.
But not in canon law, there's no problem whatsoever.
Which declaration of nullity would you recommend to be sought first, a civil one or a canonical one?
Always the canonical one first. Wait, let me rectify that. That was the stock answer, but of late precisely that's changing because of the lentitude with which the civil nullities are being counted. So the problem will be, since the ecclesiastical courts grant nullities in a more agile way because of a more perfect system, juridical system, not just a tribunal system, but a more perfect juridical framework, then the danger is that a Catholic couple gets a declaration of nullity in church, thereby rendering them capable of getting married. But then, not yet having gotten the declaration of nullity in civil court, opening them to the temptation of getting married in church without civil effects, or at least pressuring the church authorities to allow them to get married without civil effects. the so-called secret marriage that we said before, no? Which is discouraged by the church. So people are now encouraged to either file simultaneously or even file the civil case ahead if they foresee that it would be rough sailing in civil courts.
Another question about father, what if the homosexual works out as a father and supports the family? He gives he fulfills his sexual obligation to the wife, but has relations with another man. Question. Yes. I guess the question is, will the marriage be valid in that case?
Well, you see, invalidity of marriage will always have to do with the infieri. No? Are all of those things relevant? They would be relevant if they came into play in the generation of the consent. So if they did, well, okay, then investigate that. But you cannot ask it like that, no? That now this is happening, well, so what? Was that there at the time of the marriage? Did it affect the generation of the consent? Was it there to the point that you can say it constituted an incapacity to assume? Facts would belie that, because in fact, as you said, the case is that he is fulfilling his duties as a father and as a spouse. So he is fulfilling. But then there's a problem. Why he's fulfilling them, but he's not monogamous, because precisely he's a practicing homosexual. He's having homosexual relationships. Well, okay, then that angle can be seen too. If that's a proof that he is incapable of being monogamous, then yeah, you can explore that. The incapacity to assume.
If 500,000 pesos is the approximate cost of the ordinary process, as someone shared in a previous class, what is now the cost for the brief process? And for the very poor, how can they be helped since they have no money?
No, but that's not true. The 500,000, I don't know where you got that figure. The normal figure for the ordinary process in church in Manila is 60,000.
Yeah. I think the 500,000 refers to the civil aspect, to the civil process.
Yes. Civil case.
Yes, because it depends also on the value of the properties of the parties. I think the second part of the question is, for the very poor, how can they be helped since they have no money?
Well, they can be helped because there's such a thing as pro bono. At least in Quezon City, if the parish priest certifies that a case or a couple or a person who wants to lodge a petition of nullity for a declaration of nullity in ecclesiastical tribunal is really financially stressed or unable, then there's social pricing. The parish can take care of it up to a point, which the diocese matches. That's the policy in Cubao. If your parish priest certifies to it, then you can have it for free. But it's not going to be free, really. The parish has to pay half of it, and the diocese, the curia, will pay half of it, or something like that. They have an arrangement. So in other words, remember that the mind of Pope Francis is that the process for the declaration of nullity be free. So that's what everybody is trying to do. But, you have to be practical. Okay? The dioceses will do it to the extent of their possibilities or their capabilities.
If a petition for nullity is already accepted for formal hearing, is this almost certain that the annulment will be granted, since the tribunal has already found probable cause in the petition?
No, as you say, it's only probable cause. It will have to be ascertained still. No? The job of the prejudicial marriage counselors is to find probable cause so that it makes it worthy to be lodged formally into a process, because without probable cause, then it's going to be a waste of time. But it's only probable that judicial sentences are not based on probability, but on moral certainty, beyond reasonable doubt, not just probable. Because probable, almost everything is probable, right?
There are no more questions about the subject matter, but there's a clarificatory question about the assignments. What are the assignments for classes 15 and 16, and when are the due dates?
Okay, it's like this. If you notice, there have been 10 quizzes. There will be no quizzes for this particular one. It's pointless to, these are case studies. So the quizzes are the ones I have assigned. And there are 10 of them. You're supposed to hand them in because that will constitute 70% of your grade. The other 30% will be your attendance. So what's going to happen is your percent attendance in these lectures. So you attended 10 hours over 15 hours of Zoom classes, then that's 10 over 15. That's the percent. You multiply that by 0.3 because that's 30% of your total grade, and that will give you a raw score. And then you go do your exam. The exam should be, if it's perfect, 100. 1,000 rather. You add them all up, and again you get the percent. No, if you gathered 100 points in the 100 or 1,000 points in the 1,000 total, those 100%. You multiply that by 0.7 because that's 70% of your final grade. So that's 700. 700 plus the raw score of your of your attendance, and it will give you a total score. Percent of that over the perfect score, and you would get your percent grade. Passing is 75 as normal. Now, what happened to those people with imperfect attendance and watched the recording? That doesn't count. Why doesn't it count? Because there's no way for me to ascertain whether you did that or didn't do it. It's not juridical, in other words, no? Unlike logging in, when you logged in, it's on record that you logged in the classes. However, the fact that you read it will show in the exam. That's why I cannot credit you twice. No? I already credited you for the exam. I'm not going to credit you for having attended on the basis of your exam, because that's crediting you twice for attendance. Get the point?
Credit di mi yung
So
kwan.
it must be actual
Yan,
attendance.
credit lang sila. Di mi yung exam, hindi di mi yung attendance.
But I think in the end it should balance out, because if
Na,
you
pal
really
tayo,
read, then you should get a high score.
quizzes
which
lang,
should
pati
be
over and
above
assignment.
the
Hindi sila tayong kwan.
750 points
Hindi ko pwede
necessary to pass.
entra na completion. Si dyan na to attendance, dyan na
Okay.
to kwan. No,
Now, what
ko
will
pa na
happen
attendance,
next?
kaya hindi
This is our
yun.
last meeting. So I will have to compute your grades, etc., etc. And when that's done, we can call for another Zoom meeting to graduate. Now, what will happen is that we will issue certificates of completion, which will be signed by